Today I'll be discussing with the laws relating to the protection of children against violence. The previous classes I have discussed with you all the laws relating to the protection of women against violence, and now we'll be discussing on the protection of children. First and foremost, who is a child? A child means every human being who is below the age of 18 years unless, under the law applicable to the child, the age of majority is attained earlier. A nation's children are a supremely important national asset, and the future well being of a nation depends upon how its children grow and develop. It is the duty of the state to look after a child to or intending to ensuring full development of its personality. And to achieve this goal, a state must grant certain rights to the children. In India, the rights of citizens, including that of children, have been directly or indirectly provided for by the Constitution of India. We shall first discuss in brief the United Nations Convention on Direction of the Rights of the Child, hereinafter the CRC 1989, to which India is a signatory. See, CRC is a Convention on the Rights of the Child, and India is a signatory to it. Adopted by the United Nations in 1989, it is an international agreement legally binding on the parties signatory to it. It is incorporated in its various articles rights of children without any discrimination whatsoever. It was ratified by India on 11th of December 1992. It is a preamble setting out different principles the CRC is built upon. The four basic principles of CRC, that is the Convention on the Rights of the Child, are non-discrimination, best interest of the child, right to life, survival and development, and right to be heard. The provisions of CRC are categorized as part 1, that is Articles 1 to 41. It sets out the rights of the children and obligation of the governments. The rights it may be categorized as the survival rights, that is the rights of life of a child and access to basic necessities to existence such as adequate food, shelter, standard of living and medical requirements. Second is development rights, that is right to education, to practice the religion of own choice and cultural activities, freedom of thought and conscience, to play and leisure, and to access to information. The next is the protection rights that protect children from abuses, which may be consequential to several kinds of circumstances, such as children subject to procedure of criminal justice system, children in employment, children who are refugees, children who have undergone abuse or exploitation. The next is participation rights, that is rights of a children to participate in the activities of the society, especially matters that may affect their life, to assemble peacefully and to join associations. Part 2 of the Convention on the Rights of the Child, that is from Articles 42 to 45, it contains the provisions regarding implementation of the provision of the CRC. And Part 3, that is from Articles 46 to 54, it includes provisions for signing the convention by parties and rules and procedures thereafter for the purpose of ratification, enforceability, amendment, denouncement, etc. of the convention. Now see, there are three other optional protocols to the CRC which have been introduced, which are optional protocol to CRC on sale of children, child prostitution and child pornography, optional protocol to CRC on the involvement of children in armed conflict, and the third one is the optional protocol to the Convention on the Rights of the Child on a communication procedure. As of now, India has not signed the third optional protocol. Now, what are the constitutional provisions regarding the rights of the children? Our constitution has provided certain protection to the children against violence, and it is provided under Part 3, that is Fundamental Rights, and Part 4, that is Directive Principles of State Policy. Now see, Part 3, what are the provisions which tells about the protection of the children. First and foremost, the Article 14, which speaks of right to equality. that citizens of India, including children, they also must be treated equally before law and must be given equal protection by the law without any discrimination or arbitrariness. Article 15.3, it provides that discrimination is prohibited by the Constitution. However, it shall not hold a ground to prevent the state from making any special provision for women and children for their benefit. See, Article 14, it provides right to equality, which includes also the children. And Article 15, Clause 3, it provides that there is a special provision for the women and children where the state can make special provisions for them. And it does not amount to discrimination. Third provision is Article 21, which provides that no person shall be deprived of his life or personal liberty without due process of law. That means a person has an adequate right to food, shelter, clothing, etc. And it does not mean merely animal existence. Next provision which is provided specially for the children under Part 3, that is fundamental rights, is Article 21A. That state shall provide free and compulsory education to all the children falling in the age group of 6 to 14 years in such manner as the state may by law determine. The next provision is Article 23, which prohibits trafficking in human beings and beggar or any other form of forced labor. And the last provision, which is under Part 3 of the Constitution, is Article 24. It specifically prohibits the employment of children under the age of 14 years in a factory, mine, or in any other hazardous employment. And so you see, these are the various constitutional provisions for the protection and for the rights of the children, which speaks of the protection of the children against violence under the Constitution. Now, Part 4, which is the directive principles of state policy, there are various provisions under it where it speaks for the protection of children. Just as Article 39, Clause E, it states that the state shall strive to ensure that the tender age of children is not abused and that citizens are not forced by economic necessity to enter avocations unsuited to their age or growth. Article 39F also clearly expressly it provides that the state shall ensure children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity. It must also be ensured that childhood and youth are protected against exploitation and against moral and material abandonment. Article 41, it provides that the state is obliged to, within its economic capacity and development, it should provide secure provisions for educational opportunities and facilities. Article 44 of the Part 4, it provides that there should be an effort to secure a uniform civil code for all the citizens, thereby implying a uniform code for the adoption of the children too. This is one of the directive principles. The next provision is Article 45, which provides that states shall also endeavor try to provide free and compulsory education to children until they attain the age of 14 years. The next, under the directive principles, you have got Article 46, which provides that it is the duty of the state to promote the educational and economic interests of the weaker section of the society with special care and therefore the children therein. Article 47 provides that the state is duty bound to raise the level of nutrition and the standard of living and to improve public health, including that of children. Article 51C, it provides that international laws and treaties shall be respected by the state to every possible extent, including the CRC and its optional protocol. Optional protocol to CRC on sale of children, child prostitution and child pornography, and optional protocol to CRC on the involvement of children in armed conflict. Article 51AK, it is a fundamental duty of every citizen of India who is a parent or a guardian to provide opportunities for education to his child, or as the case may be, ward between the age of 6 and 14 years. Then under the Constitution, there is also Article 243G, which provides for the institutionalization of a child care by seeking to entrust programs of women and child development to panchayats. Now see, these are various protection or provisions for the protection of children under the Constitution. Now, do you see right to constitutional remedies when rights of children are infringed? See, if the above mentioned fundamental rights are infringed, where will we approach? The appropriate courts must be approached, and the Constitution has provided the remedy for it. And it is provided under Article 32 and 226, where you have the right to move to the Supreme Court to protect your fundamental rights under Article 32, and under Article 26, where we can approach the High Court by virtue of this right article. You can get your rights protected, and not necessarily it should be the fundamental rights. See, the difference is that whenever you can approach the Supreme Court under Article 32 whenever your fundamental rights has been infringed, but under Article 226 whenever any of the rights are violated, you can approach the High Court other than the fundamental rights. The courts, for the purpose of protecting the rights, you may issue writs. As you know, there are 5 writs: habeas corpus, mandamus, prohibition, certiorari, quo warranto. Habeas corpus means whenever you, it literally means you may have the body. A person, whether or not a child, who is detained, whether in prison or privately, is directed to be produced before the court. If found that such detention was illegal, he is released. So you can file a writ petition, that is habeas corpus. Next writ is your mandamus, which means command. It is issued by the Supreme Court or the High Court, orders where it orders the lower court to perform a public or statutory duty which they are obliged to perform but have failed to do so. The next writ is a prohibition. It is issued by the Supreme Court or the High Court to prohibit the inferior courts under them from transgressing the limits or powers vested in them. The fourth writ is a certiorari, which enables a superior court to question order already passed by the inferior court or tribunal or quasi-judicial authority. The last writ is your quo warranto, which literally means by what right. You can question. It is issued to restrain a person from holding a public office he is not entitled to hold. See, these writs may be extended to the lower courts by the Parliament. Now, since children are unable to access the legal system by themselves, as I have already told you, that one of the constitutional remedies under Article 32, another is Article 226, where you can file a writ petitions. There are 5 writs. And since, the children are unable to access the legal system by themselves, a public interest litigation, that is PIL, may be filed in the Supreme Court or the High Court by a public-spirited individual. That means by anyone, by any public-spirited individual or a non-governmental organization against the central or the state government or any of the respective agencies by the virtue of Article 32 and 226 for protection of the rights of the children. So you see, there are various protections which are available under the Constitution, and the constitutional remedy also if there is infringement of this provision.